times in Europe, if you were accused of a crime or misdemeanor, you had to go through what they called trial by ordeal. This was an idea that first surfaced some 3,000 years ago in the time of Hammurabi. One of these ordeals called for you to plunge your hand into boiling water. 3 days later, if the hand healed, you were pronounced innocent. Another trial by ordeal was even more extreme. It demanded that you be tightly bound and thrown into the water. If you floated, you were guilty. If you sank, you were innocent. Was this fair and impartial justice? They thought so.
The idea of justice has come a long way since those medieval times. For Americans, there's no trial by ordeal, no divine right of kings or emperors, no dictators, orders, or whims. At the very foundation of our democratic society is the guarantee to each and every one of us of the right to a fair trial by jury. Each day in courtrooms across America, thousands of judges, attorneys, court officials, and jurors do their part to uphold this promise. Most disputes never make it this far. They're resolved out of court. Our system of justice, which is truly unique, works because it allows each side to present its case in front of a group of diverse citizens drawn from the community. Under the watchful eye of the judge, the jury observes as each side states its case. Once a jury hears all testimony, it decides which case best meets the burden of proof as defined by the judge. There's simply nothing like it. Yet many Americans take trial by jury for granted, and that's a shame, because jury service is much more than a call to duty. It's a privilege and an honor, one that our ancestors fought for and died to preserve. When you're on a jury, your opinion matters. You have a voice. As a juror, you actually participate in government as you protect the rights of others. As an American juror, you can influence the outcome of a trial, and in so doing, truly make a difference that can actually change lives.
Jury service may be strange to you, so a short explanation is in order. Those who participate...
America has two court systems, state and federal. Different types of cases are heard in different courts. Ohio's trial courts fall into two categories, common pleas and municipal or county. Both civil and criminal matters can be tried before a jury. Civil issues generally involve a monetary or property claim.
Ladies and gentlemen, you have been summoned as prospective jurors.
Common pleas courts handle felony criminal cases. These cases allege serious criminal acts, such as assault, robbery, breaking and entering, and some drug-related charges. They also decide civil cases, including having exclusive jurisdiction in civil cases with claims over $15,000. Different divisions of common pleas court also handle domestic relations, wills or probate matters, and juvenile cases. Municipal or county courts hear criminal and traffic misdemeanors. They also decide civil cases with claims under $15,000. In a criminal case, the accused is called the defendant. The state or municipality that brings charges is the prosecution. In a civil case, The one who brings the case to court is called the plaintiff. Again, the one against whom the claim is filed is the defendant. Court cases include different and often contradictory claims and facts. Jurors must listen well to all testimony and then decide which is true. Jurors must have integrity, sound judgment, and be completely impartial. As a juror, you must provide the same high level of service you would expect were you on trial.
I think being open-minded, that you have to set aside some of your own beliefs in order to be objective, to be fair, to listen, to weigh what you hear, and take that and use it fairly. That's sometimes difficult, but I think most people can do that because they want to be fair and they want to be just.
Names of potential jurors come from records of registered voters or a combined list of registered voters and licensed drivers. This varies by jurisdiction.
All rise. The Honorable Joseph Clark presiding.
Several people work in the courtroom. They may have a number of different responsibilities depending on the court. In the courtroom, the judge is in charge. It's the judge who interprets the law. It's the jury that must weigh the facts. A bailiff or clerk, who are both court officers, work closely with the judge to help make sure that the trial goes well. Court officers help jurors communicate with the judge. They may also help with special needs of the jurors. A record of each trial is made. In many courts, a court stenographer or court reporter keeps track of every word. In some courtrooms, this is electronic. Cameras, video, and voice recorders document all proceedings. In a criminal case, the attorney representing the state is called the prosecuting attorney. Defense attorneys represent the accused or defendant to protect his or her rights.
Ladies and gentlemen of the jury, my client.
In civil cases, the attorney who files a complaint is called the plaintiff's attorney. The defendant's attorney represents the party against whom the claim is filed. Witnesses may be called in to testify as to what they've seen, heard, or observed.
Raise your right hand, please.
There may also be spectators in court. These include family members of either side, reporters, students, and just curious citizens. Everyone must show proper respect for the court.
My experience, I would like a potential juror to know that preconceived notions, prejudices, first impressions should be parked where your car is parked. Bring in freshness of mind, be open to the letter of the law, understand what is asked of you.
Jurors must be completely fair and open-minded. Personal feelings must not impair a juror's ability to consider all sides. To help qualify jurors, attorneys ask them questions. This is called voir dire, a French word that means speak the truth. Voir dire helps attorneys identify any juror they think might be too close to a case or too friendly with those involved in a case. Voir dire tries to find out if a potential juror has specific knowledge of a case. It also examines personal opinions or biases a juror may not be able to set aside. Voir dire looks for any personal experiences or relationships that may affect a juror's impartiality. If a juror is found to have a relationship with members of either side, they will likely be challenged and excused. Each juror may be addressed individually. Questions may seem personal. Either side may challenge a juror. Jurors must not take challenges personally. Counsel is just doing its job, which is to select jurors they feel are best suited for a specific case. There are two types of challenges: challenges for cause and preemptory challenges. A challenge for cause requires a reason. If the judge feels cause is sufficient, a juror may be excused. For a preemptory challenge, no reason needs to be stated by the attorney. Attorneys are allowed a predetermined number of preemptory challenges. When a juror is challenged and excused, It's no reflection on his or her honesty. Attorneys must excuse anyone they or their client feels isn't suitable for a specific case. The same attorney that excuses a juror from one case may find that same person ideal for another. In criminal cases, common pleas courts choose 12 jurors. In municipal court, only 8 jurors serve. The court may also select 1 or 2 alternate jurors for a trial. Alternate jurors step into a case if any juror falls ill during trial or can't finish for a valid reason. This allows the case to continue. Once selected, the judge orders the clerk to swear in the jury.
And raise your right hand, please.
The clerk recites an oath. Jurors either swear to it or affirm. Now it's official. We have a jury.
The defense is going to show
Both sides make opening
that
statements.
my client
These aren't evidence, it's simply their sides of the story.
will, however, give you
The plaintiff or prosecution then calls witnesses and presents evidence. Then the defense does the same. The jury must listen carefully to all the facts presented by both sides. This includes all physical evidence, weapons, photos, and crime scene exhibits. The rules of evidence are complex. The judge may instruct jurors to ignore certain statements or exhibits because he or she deems them inadmissible. Based on the facts presented, each juror must form an opinion about guilt or innocence in a criminal case, and about which side should prevail in a civil case, and about which set of facts best meet the required burden of proof. Some courts allow jurors to take notes. Others permit jurors to write out questions for witnesses. The judge will provide more direction if either notes or questions are permitted. Attorneys may step up to the bench to talk privately with the judge at points during trial. These conversations are not for the jury to hear. Typically, they cover technical aspects of law or procedural issues. Closing arguments made by both sides summarize how the plaintiff or prosecutor and the defense view their cases. Like the opening statements, closing arguments aren't evidence. These are the different sides' opinions about the testimony and evidence presented during the trial. The judge must interpret the law, but it's the jurors who must determine the facts. At this point, presentation of evidence is over. Both attorneys ask for a verdict in favor of his or her client. The judge instructs the jury on the laws that apply to the case. The jury must pay close attention and apply those instructions to arrive at the verdict.
Appearing the instructions are complete, the bailiff will take the jurors, the verdict.
The judge also gives instructions in writing to the jury. The jury then leaves the courtroom to discuss the facts of the case and determine how to apply the law to the facts. This is called deliberation. These private discussions are for members of the jury only. At this point, the jury elects a foreperson. The foreperson is a juror who oversees the deliberations and conveys any juror questions to the court for answers. The foreperson also sees that the deliberation is orderly and that every juror has an opportunity to freely express his or her opinion.
Ladies and gentlemen of the jury, it's my understanding that you have reached a verdict. Who is the foreperson of the jury? Ms. Harrison, would you please hand the verdict form to the bailiff?
The verdict is then read in open court. The judge may poll each juror to confirm that this is in fact his or her verdict. The judge then thanks the jury. At this point, jurors are released from their service on the case. The judge and/or the attorneys may wish to speak with the jurors after the trial is over. Once the trial is finished, jurors are permitted to speak about the case, but are not required to do so. Most people can serve on a jury, even those with special physical needs. You may wonder if you'll be able to take enough breaks throughout the day to stay comfortable. In most cases, that's not a problem. We're all busy. We have commitments. It may not always be convenient to serve. But what if no one was willing? Some of us fear the worst when we first get called for jury service. We think it will totally upset our routines. As long as one provides proper notice, employers may not discipline or threaten to discipline anyone who must miss work to serve on a jury and who has properly notified his or her employer about their jury service responsibility. The court also pays jurors for serving. What the court pays is nominal, and it varies from court to court. By law, no one from either side may contact a juror in an effort to influence a verdict. If this happens, jurors must report it to the judge or court officer immediately. Once the trial is over, a juror's name may become a matter of public record. For most Americans, serving on a jury is an experience they never forget. We all know our democracy exists, but as a juror you see it up close and in action. Jury service can be one of the most rewarding experiences in your life, and it's one of the few ways you can actually participate in our system of justice and experience firsthand the wisdom of our forefathers.